probably the most irresponsible and reckless statements that were made and facilitated, may I add you, by the Speaker of the House, was the situation over the Daher Mall. Richard Fedrick, on his show a week or 2 weeks ago, and also repeated the statements in the House yesterday, is alleging that the Stephenson King administration bought the Daher Mall. So I want to say that that's categorically not true. The fact is the Daher Mall was in receivership with First Caribbean. First Caribbean had agreed to lend the money to purchase the building and also to lend the money to redevelop the building. So approximately $30 million EC for the building and another $60 or $70 million to rebuild the building. In total, about $100 million. Unfortunately, during the tenure, 2006 to 2011, United Workers' Party was not able to get that project off the ground. And when the new government came in 2011 under Dr. Anthony, they went ahead and they took the loan from First Caribbean. And the $100 million was borrowed in the House, and $30 million was used to purchase the building, so it means it automatically went to pay off First Caribbean. But the $70 million that were supposed to be used to redevelop the facility was used to fund the government's budget. So the responsibility of the interest was only on the $30 million, and the sad part is that to develop the building, in order for it to can pay for its own way, the building was left there unoccupied and as an eyesore for the public. And it had been that way for a very long time. So when I came into government, the decision to have purchased the building was already made. So it now was an asset of the state, in which we were paying interest on a non-performing asset. Non-performing asset in that the building hadn't been repaired, there was nobody renting the building, there was no activity in the building. So in essence, it was, as we would say in St. Lucia, it was just there. And I attempted, through the board of Amazona, to sell the building. And after several attempts, though failed attempts, we eventually found a developer that was prepared to purchase the building, but with the understanding that the government of St. Lucia would guarantee the rent upstairs. Those negotiations, while in good faith, I did not believe, when it was presented to me as a Minister of Finance, presented the best option for St. Lucia and for the government. So what we chose to do was to sell the building and to sell the ground floor of the building. And we sold the ground floor of the building for $13.5 million EC dollars, approximately. And that is verified in the deed of sale, the deed of sale that was produced and executed on the 26th day of March of 2020. And it's the document that the Speaker of the House and also the MP for Castries Central made reference to. Now, I made the claim that we'd sold the ground floor, and in essence, the purchaser was going to develop the upstairs part for the government, and that therefore we would be paying rent to the purchaser in the tune of $4 a square foot for 15 years. And that $4 really was not to pay for the building, but was to reimburse the purchaser for the works to fix up the building. Because remember, previously it was going to cost about $70 million to fix up the building. So we estimated that it was going to cost maybe about $50 million to fix up upstairs. And it's not only to fix up the building, but it's also to fix up all of the public spaces, the car park, the fencing, to redo the plumbing and all the electrical works, because that building had remained dormant for a long time. The MP, supported and aided and abetted by the Speaker of the House in reading the deed of sale, claimed that I was lying, and said that we sold the building for $13.5 million, and that we then turned around and rented the building for $4 a square foot on top of that. And the innuendo was being made that this was a sweetheart deal. Now, the part that the Speaker of the House and the MP did not read in the deed of sale, which I will read for you all now. It says, whereas the vendor is desirous of developing the property and has for the purposes entered into that certain development agreement with the purchaser dated the 27th of February 2020 prior to the execution of this deed. So in essence, what it's saying, that the government and the purchaser had entered into a development agreement prior to this deed of sale being made. It then went on to say, in consideration of the sum of 5 million United States dollars, or 13,584,500 Eastern Caribbean dollars, paid by the way of a mutual undertakings of the parties, hitherto as set forth in the development agreement, and the obligations of the purchaser as developer to the vendor, adequacy whereof it is hereby mutually accepted by both parties. The vendor hereby sells and conveys free and clear of all encumbrances unto the purchaser, therefore accepting the immovable property described in the first schedule. And the first schedule goes on to describe the Daher Mall, the land, and the building. So while it may give everybody the impression that the entire building was sold for $13.5 million, it makes reference to the development agreement. Now, we have in the Speaker of the House a want-to-be lawyer, who we know that went and advised himself on the Privileges Committee case and had to go to court. And in court, rather than allowing the case to be heard, consented that he made a mistake. So the case, unlike what he was saying, was adjudicated. It was trial. It was a case to be heard. And he came to the court and said, mi culpa, my fault, and accepted that he had made an out and that he had abused his authority. And here it is again that he is pretending to be a lawyer in reading a document. But what is more egregious, what is more irresponsible, what is more reckless, is that the MP from Castries Central is a lawyer. And for him to interpret the deed of sale, and considering the deed of sale makes reference to a development agreement, and not to quote the development agreement, is either that he is careless, a weak lawyer, or malicious in his pursuit of Alan Chastanet. So I want to make reference. The development agreement, dated the 27th day of February 2020, and with everybody's signatures on it. The agreement has its preamble and with all of its definitions. And in section 2, it says, in consideration of the consideration and contemporaneously with the execution of this agreement, Amazona, which is the company that owns Daher Mall, hereby agrees to execute transfer by way of deed the whole property free and clear of all encumbrances, with vacant possession by subject to clause 12 hereof, and represents the warrants that it is the sole legal. So in essence, Amazona is transferring the entire property over to the purchaser. And that's what the allegation is, that the purchaser purchased the building for $13.5 million. Says the developer, which is the purchaser, undertakes to execute the development and the basic fit-out of at the developer's cost within a period of 18 months from the commencement date or such longer period as agreed to between the parties. That the developer shall be at liberty to create a hypothesis obligation charging the whole property by way of the security in favor of the third-party financial institution. So in essence, we're given, and the reason why the property was transferred entirely to the developer is so that he can hypothecate, he could mortgage the building on the loan. That the developer may assign the rent to the financial institution. So the rent that they're paying, which is the $4, which is a lease agreement that was prepared, and there's a lease agreement that was signed, that they could automatically transfer those $4 a month to the bank to help repay the bank for the development of the site. Amazona agrees to procure that the government of St. Lucia agrees to enter into the lease for the leased area, comprising of the 78,000 square feet. The developer agrees that the lease rate to be paid by the government of St. Lucia to the developer under the lease shall be exclusive of maintenance expenses in relation to the payment. In the event that the rent is not paid on the first day of each month of the lease term, Amazona agrees to procure the government of St. Lucia shall be liable to pay the interest. So it means that Amazona and the government are agreeing that if Amazona itself is not in a position to pay the rent, that the government of St. Lucia would be obligated to pay the rent for Amazona. Now, here's the interesting part. So section 6 of the development agreement says, on the expiration of the lease, provided that there are no defaults by the government of St. Lucia or Amazona under the provisions of the lease of this agreement respectively, or any outstanding sums owed to the developer in relation to rent or otherwise, the developer shall re-transfer all its rights, title, and interest in the leased area to Amazona, including a provision permitting Amazona the exclusive use of, in perpetuity, of 50 car parking spaces, as well as the use jointly with the developer of all other car parking spaces in the common area. By executing a deed of transfer to effect a vesting in Amazona of the absolute ownership of the leased area, which is the 78,000 square feet, which is the second and third floor, free and clear of all encumbrances. For avoidance of doubt, the parties reiterate the agreement set forth in clause 12. Clause 12. The parties hitherto do hereby agree that the doctrine of merger is specifically excluded, and that the obligations, undertakings, and the duties herein contained shall survive the execution of any deed made pursuant to this agreement. Now, for both the Speaker of the House, and even more so for Richard Frederick, to deliberately not include that in their description, again proves once more that Richard Frederick is the master of half-truths. And that he's playing on people's cynicism of government and politicians. And he knows it all too well. So I want to let everyone know that I take this very seriously. I have 3 defamation cases against Richard Frederick, which sadly have not been heard. But now, with the Privy Council hearing the case between Ernest Hilaire and myself, hopefully that impediment will be resolved very soon. But I have asked my lawyers to review this particular statements and what has transgressed over the last week, with the intention of taking Mr. Frederick again to the court. But I have to say that what took place in the House yesterday, where I was accused of being a liar, I was accused of somehow trying to pull wool over people's eyes, that I, as a Minister of Finance, was making irresponsible decisions to come at the expense of the people of St. Lucia. So here's the truth. So here's a building that we now know that Kenny Anthony and his government bought. So $30 million was borrowed. And that was borrowed for an asset that was producing nothing. So in essence, it means that the state was paying the interest. The asset itself was not being put into productive use. And we came in, and we've now found a solution, and people can pass by and see the work that's taking place. And to take an asset that was just derelict, now to put it as a productive use. But here's the point, that we're going to pay $4 rent for 15 years. And that $4 is really to pay back the developer for borrowing the money himself and not having to come at the expense and exposure of the state. And we have a choice as a government. We can find office spaces that we're currently paying more than $4, and there are a lot of office spaces that we're paying as much as $7.50. Or we can rent out that office space to somebody else, probably at $6 and $7 or more. But let's say we're going to save the $3.50. So the $3.50 that we're going to save for the first 15 years at $78,000 a square feet is almost $45 billion. And then now, the next 15 years, there's no rent. All the repairs would have been paid for. So it means now for the next 15 years, you're going to save $750, which is going to come to more than $100 million in savings. So that building now would actually be paying taxes, generating jobs, become a productive asset in the economy, and the government of St. Lucia would save over $150 million in its own rental expenses, or generate over $150 million in revenue. And yet, they want to allege that I was an irresponsible Minister of Finance. Now, let us juxtapose that